So let's talk about citation and the Blue Book. One of the challenging aspects of legal studies is learning how to refer to legal authorities in the proper fashion. A series of law review editors got together and created what we commonly call the Blue Book. And this is the guide to citation. It is 560 pages long. And I have to admit, I always resisted as a law student as much as possible dealing with it, but you can't avoid it. And so here it is. My hope is to break it down for you into manageable bites, so at least you feel you have a solid foundation in terms of citing things that you're going to need as a practicing attorney. So this is what the Blue Book looks like, if you can see on the right. While it's not required for this class, I highly recommend you purchase a Blue Book. You will use this throughout your legal career, and it's something that you need to have. The Blue Book is an intimidating book when you first look at it. Knowing that there are that many pages devoted just to how you refer to specific types of legal authority can be intimidating. But let's break it down. When you actually have the Blue Book in your hand and you flip through it, you will notice that the first pages are blue, like literally blue. And that's where we're going to focus our attention in this class. Though if you have the 20th edition, those are pages 3 through 56. We're also going to look at the tables in the back, and I'm hoping today to kind of tell you when you need which table. The white pages in the book tend to go into great level of detail regarding specific rules. We are not using those for this class. Those pages are devoted to academic publications. So for example, if you're writing a law review article, you need to pay attention to the white pages. But if you're a practicing attorney and filing something in front of the court, you are concerned with the blue pages in this book, as well as any local rule that particular court has put forward regarding citation. But the foundation of all of it is the Blue Book. So I like to think of portions of the book being our friends. One is the index. Also, the other part is the quick reference. If you turn your Blue Book to the very last 2 pages, it's actually part of the back cover and the page before, you will see something called quick reference, court documents and legal memoranda. And that's always a good starting point. At least it gives you the basic citation form for a variety of materials that you're going to deal with. And my expectation is not that you will become the perfect citer, but a very good one, and that you will understand how the rules work and why they work the way they do. So let's get started. Another comment before we get started: if you physically look through the Blue Book, you will see times when they use small caps, which is a particular font, in order to refer to book names and other proper names. Ignore this. This is not something we use in court documents or in legal memos or in this class. For our purposes, when you have a case name, you either use italics or underlines. I prefer underlines, but if you prefer italics, that's fine, but do not use small caps. For the writing course, please talk to your professor to find out what they prefer. Okay, why do we cite? What is it that requires us to cite? I remember when I started legal writing, I discovered that almost every sentence I authored had to have a citation. And that was a real adjustment for me. And the purpose behind it is, one, to tell the reader, which is usually a judge, that you're not making this stuff up. That in fact you have compelling legal authority to support your position. The judges aren't interested in your own personal opinions. They want to know what the law says. And without a citation, they have no idea whether the particular ideas you are expressing are your own or they belong to legal authority. The other thing it does is tells the readers the weight of the authority. When I read legal materials, I'm very aware of which court put forward an opinion, if it's an appellate court, if it's a court that's under my jurisdiction, or if it's a court outside our jurisdiction. And those things tell us how much to weigh the specific authority that's being presented. It also reminds the readers that these ideas are not yours and prevents accusations of plagiarism. Plagiarism is something really important, and you need to know that plagiarism is representing another's ideas or words as one's own. And it's very important, especially as we study, to make sure that we do not engage in plagiarism. So I just put that out there. Let's talk about the next thing. So when should you cite? This is also important. Whenever you assert a legal principle, you have to cite a case. As you can see here, to be valid, a will must be signed. You have the case name, citation, and the name of the court and the year. If you just put down to be valid, a will must be signed, and there was no legal authority after that, there's no proof that what you're saying is true. You should also cite when you refer to or describe the content of an authority. The court held the defendant's conduct rose to negligence, and there's the citation. So now we know what the court decided in a particular case, and you have the citation to prove that it's true. In that case, you've actually provided the page number, 25, in addition to the general citation. You should also cite when you quote directly from the source. So you could say, Marcantel is a lousy professor, but a snappy dresser. So that's a quotation. Anytime you quote from the court or a legal authority, you need a citation. That's not only important for plagiarism purposes, but it also tells the court that this is the exact language used by the legal authority. You also cite generally when the ideas you're presenting are not your own. I predict the exclusionary clause is a waning concept, and so there's a citation. You want to make sure you do this in all of your legal writing. I remember feeling like every sentence I wrote had to have a citation. While that's not exactly the case, it's not far from it. So what is a legal citation? This is the basic citation form for cases, and I'm hoping to provide you with specific Bluebook instruction by subject. So today we're talking about cases, and we're going to walk through Bluebook citations for cases. Other classes will be focused on statutes and administrative regulations and secondary sources. And in those classes, I will give you instruction for those types of authorities. I feel like the Bluebook can be somewhat overwhelming, and that if we can start with one topic and then proceed to the next, it's an easier way to get your feet grounded. So Bluebook rule number 10. So again, I'm in the blue pages of the Bluebook, and I'm looking at rule number 10. And this tells you how to cite a case. So you have here Herrick v. Lindley, 391 Northeast 2nd, 729, 731, Ohio, 1979. This is a very common citation. And let's break it down so you know what the heck you're looking at. So when you give the case name, you are providing the last name of the plaintiff, the person bringing the action, and the last name of the defendant, the person or organization which is the object of the action. So even if Mr. Herrick's name was Joe Herrick and Mr. Lindley's name was Fred Lindley, you would only put down Herrick v. Lindley. And you must underline it or italicize it. The next thing you do is you put down the volume of the reporter. So this is actually the big number on the outside of the book. So in this case, it's the 391th volume of the Northeast 2nd Reporter. Northeast 2nd tells you the name of the reporter. Remember, we talked earlier about regional reporters. So if this were a Missouri case, it would be Southwest 2nd or 3rd, and so on. So when you're looking at that section of a citation, it's telling you the name of the reporter, where the case originally came from. And that's important. Even now that we're in an electronic online world, this is still the way cases are identified. The second number you see, 729, after Northeast 2nd, is the page number where the case starts in the physical volume. So if you were holding that book right now, you could turn to page 729 and you would find the case of Herrick v. Lindley. After that, there's a comma and another number. What that number refers to is what's known as a pinpoint citation. So say there's one part of the opinion in Herrick v. Lindley that's really good, that's exactly like your case in front of you and says the law in a way you like it. If you're going to refer to that specific portion of the opinion, you're going to write down the page number where it exists. So here, something really cool happened on page 731. But you want to make sure that's there, because what courts will do is they will analyze your citations. I used to be a clerk for the Colorado Supreme Court, and we were charged with looking over the citations people put forward in their briefing to make sure it was true. And so you will have court clerks looking on page 731 to see if the case really says what you said it did. After that, within a parenthetical, you identify the court making the decision. This is the Ohio Supreme Court. You know that because it says Ohio, and the year of the decision, 1979. So this is the basic blueprint. You want to kind of get very comfortable with this blueprint because this is how you're going to see cases referred to. I want you guys to emphasize pages 10 through 17 if you have the 20th edition of the Blue Book and read them very closely. This is all the rules that we're concerned about in terms of case citations. And the reason that we're so focused on the manner of case citations is because we're answering two questions in our heads usually. Is this still good law? And what's the weight of authority? Because common law is an evolving thing. A case may appear, and then 10 years later, another judge might question it, and that case may no longer be good law. So you definitely do not want to cite a case that's no longer good law. And the citation is a way of ensuring it's good law, and is also telling the reader the weight of the authority. Is this a U.S. Supreme Court opinion? Then it may have a lot of authority. Is this a district court in Connecticut opinion? That might not have much authority at all here in Missouri. So those are the things that push us to identify citations and things you want to consider. To boil it down, a full case citation must include the name, so those are the two parties, their last names, the source, i.e. the name of the reporter, that was that Northwest 2nd, Northeast 2nd, the deciding court, the year of the decision, any parenthetical information, and the subsequent history of the case, if any. And those have to appear in your citations when you're talking about a case. People who put the Blue Book together are very exacting folks. And when you put together the name of the case, they have provided tables of abbreviations. So if you have a really long case name, the University of Washington, you don't actually spell out the full word university. Instead, you would go to the case name table, which is in table 6 at the very back of your Blue Book. And I provided the page numbers for the 20th edition, and it will tell you, how to simplify the name of the party in the case. And so if part of the party's name is investment, for example, then you would actually use INV period in the case name. That's just one example, but you will see there are a number of words where the expectation is that you will abbreviate it. University is UNIV period. And courts will expect that when you're putting your citation together. So remember, case name, look at table 6. So let's look at another thing that can happen when you're describing case names. Sometimes case names involve geographic units or locations, and those appear in table 10, sorry. And in that case, if the case involves Alabama, Michigan, and also the courts of those states, this is how you would abbreviate their names. So for example, if you're dealing with a Missouri issue, it would be MO. For Kansas, it is dealt with in the table 2 as just KAN. So if you have to put a geographic unit in your case name or the deciding court's name, use table T10. The second item, the name of the reporter, There are very specific forms for describing the reporters. We talked about the regional reporters and the federal reporters, and each of those has their own citation form. Table T1 in the back of the book goes through exactly how you identify every reporter. And it's analyzed alphabetically by federal and by state. So if you're in a jurisdiction you don't know about, you go to table T1, you find that name of the jurisdiction and find out what the reporters are. In terms of the deciding court, there are also rules around how you abbreviate those. And those are in table T7. So just remember that 1 through 5 are mandatory in citing a case, but there are tables that are connected to those rules. And the expectation of following those abbreviation rules is strong. And so when you write citations, the expectation is you will follow those tables. Another thing that's very important is subsequent case history. This is important because if you cite a case and don't include what happened afterwards, the courts will be very angry if that case is no longer good law or if the holding has changed. So we'll go into later how you update cases to make sure your research is the most current, but do remember that when you're citing a case, you need to make sure and discuss what happened to the court decision if it was appealed. So here we see a case, a federal case that was in Pennsylvania. At the district court level, there was an opinion that was affirmed at the Third Circuit and also affirmed by the U.S. Supreme Court. In many cases, you might have reversed by the Third Circuit and then affirmed by the Supreme Court. So you really want to know the case history and you want to cite it. In terms of the abbreviations that are expected, table T8 provides those. So you know that affirmed with AFF and then apostrophe D means affirmed. REV apostrophe D means reversed. So that is very much critical. You can lose your credibility as an attorney if you cite a case in front of a court which is no longer good law, or if you cite it and do not include its subsequent case history. There are also explanatory phrases that you can use with decisions. So sometimes you do it because you don't want to have a full 3-paragraph discussion of a case, but you want to cite a particular portion of it or to explain the weight of that authority. So this is, say you cited Bush v. Gore, which was a case involving the election in that year. It was a 5-4 decision. And here you're actually quoting the dissenter, Justice Breyer, and their specific quotation. But in reading this, I know that this is actually not the court's opinion. So while I might find this persuasive and interesting, I know that this is not binding on anyone. This discussion, the political implications of this case for the country are momentous, is certainly profound and worthy of analysis. But if you are citing Bush v. Gore, you cannot cite it for the proposition that the court held that piece of information to be true. It can briefly explain what the case stands for. So this is a case holding that in Green v. Georgia, the U.S. Supreme Court held that the exclusion of relevant evidence at a sentencing hearing constitutes denial of due process, which is a constitutional guarantee. So I like to use those sometimes when I'm explaining a proposition and that several cases support it. You might use string cites where you have several cases and you use a parenthetical to just describe the holding. Short form citation is something else you want to know after you have provided the full citation to a case. In your legal memo or your brief, you can then use a short form and later citations to the same authority, as long as the reader can easily find the full citation. So say you are citing Palsgraf versus Long Island Railroad Company, and it's 162 Northeast 99, a New York case from 1928. You've already provided that full citation, but you want to refer back to that case again in the next paragraph. So there are a couple ways to do it. You can cite Palsgraf, you can give the volume number, the reporter, so the volume is 162, the reporter is Northeast, and then you use at 100. At tells the reader you're referring to a specific page. Notice here 100 is a different page than the original 99, which was the page the case started on. Just as a convention, you typically use the name of the first party in order to identify the case in short forms. There are some exceptions if it's a very common term or it's something that will not help your reader actually find the case. Another short form, if you refer back to the case, is just the reporter, volume, citation. So you could do 162 Northeast at 100. The third one can be very helpful, but it has a special rule. This is id at 100. So instead of having to retype everything again, as long as Paul's graph is the last case you just talked about, you can put id, period, both underlined, at 100 with the page number, but it only works if it is the authority immediately prior. If, for example, you've cited another case in between, you can't use id. So I know this can be overwhelming. There are many, many rules in the Bluebook, but let's focus on cases right now and know that, today and this week we're just focused on cases. And the portions of the Bluebook I have identified, so you want to focus on the blue pages, on cases, as well as the tables and get to know those. One thing that is helpful though, if you just feel completely and totally lost, sometimes there are things within Westlaw and Lexis that can help you. For example, I tend to use Westlaw the most. And sometimes if you're writing a paper and you just feel like, wow, I have no clue even how to start this citation, there's a feature in Westlaw, and if you look at the circled area of the screen, it's called Copy Citation. And it looks like a couple Post-it notes next to each other. When you click that arrow, it gives you these choices: Copy Link and Copy Citation. When you do that, it actually gives you what Westlaw believes to be the Bluebook citation for this case. So you get Simmons v. State, 459, which is the volume number, Southwest 3rd, so it's the Southwest Reporter, page 503. It's a Missouri Court of Appeals decision from 2015. So it allows you to copy citation and put it in your document. And so I always think that that can be a starting place, but you don't want to completely rely on it. Sometimes Westlaw gets it wrong. But it can help you as you're starting to do this to see what a good citation looks like and get a sense of what the reporter is and how courts are referred to. But I ask that you always back that up with an examination of the Bluebook, because it's not always right. But it is a good starting point if you feel confused.